5 seconds. Start. Point 2. Where, however, a refund is claimed on the ground that the preposition of the act under which it was levied is or has been held to be unconstitutional, such a claim being a claim outside the purview of the enactment can be made either by way of a suit or by way of a writ petition. The principle is, however, subject to an exception colon where a person approaches the High Court or the Supreme Court challenging the constitutional validity of a provision but fails, he cannot take advantage of the declaration or unconstitutionality obtained by another person on another ground. This is for the reason that, so far as he is concerned, the decision has become final and cannot be reopened on the basis of a decision on another person's case. This is the ratio of the opinion of Hidayatullah C.J. in Tilok Chand Moti Chand versus H.B. Munshi 1969. Such a claim is maintainable both by virtue of the declaration contained in Article 265 of the Constitution of India and also by virtue of Section 72 of the Contract Act. In such cases, period of limitation would naturally be calculated taking into account the principle underlying clause C of subsection 1 of section 17 of the Limitation Act 1963. A refund claim in such a situation cannot be governed by the provisions of the Central Excises and Salt Act or the Customs Act as the case may be, since the enactments do not contemplate any of their provisions being struck down and a refund claim arising on that account. In other words, a claim of this nature is not contemplated by the said enactments and is outside their purview. Point 3. A claim for refund, whether made under the provisions of the Act as contemplated in Proposition 1 above or in a suit or writ petition in the situations contemplated by Proposition 2 above, can succeed only if the petitioner oblique plaintiff alleges and establishes that he has not passed on the burden of duty to another person oblique other persons. His refund claim shall be allowed oblique decreed only when he establishes that he has not passed on the burden of the duty or to the extent he has not so passed on as the case may be, whether the claim for restitution is treated as a constitutional imperative or as a statutory requirement. It is neither an absolute right nor an unconditional obligation, but is subject to the above requirement as explained in the body of the judgment, where the burden of the duty has been passed on. The claimant cannot say that he has suffered any real loss or prejudice. The real loss or prejudice is suffered in such a case by the person who has ultimately borne the burden, and it is only that person who can legitimately claim its refund. But where such person does not come forward, or where it is not possible to refund the amount to him for one or the other reason, it is just and appropriate that that amount is retained by the state, that is, by the people. There is no immorality or impropriety involved in such a proposition. Stop.